Hey guys, Tim Anderson for the third time today. I'm very sorry to make your phones be dinging all day, but I wanted to talk about 18 USC 926. Now, I did a video earlier today. I got a policy violation from Facebook. It's been removed, so I'm going to re-record it. So if you've already watched it, you don't need to watch this again, but I'm just re-recording it because of a policy violation. So I've been asked to think outside of the box, and I just wanted to talk to you about something that's been starting to float around under 18 USC 926 and 927. Now, I've already done this, so if you've already seen this video, you can disregard it. You can turn it off. But if you haven't, this is it. There's something called the Firearm Owners Protection Act. And specifically, it states that no such rule or regulation prescribed after the date of the enactment of the Firearm Owners Protection Act may require that records required to be maintained under this chapter or any portion of the contents of such records be recorded at or transferred to a facility owned, managed, or controlled by the United States, any state, or any political subdivision, nor that any system or registration of firearm owners, firearm owners, or firearm transactions or dispositions be established. Nothing in this section expands or restricts the Secretary's authority to inquire into the disposition of any firearms in the course of a criminal investigation. Now, first off, this is a federal code. It only applies to the federal government. However, I'm trying to think outside of the box. What could we do to go to court and fight about Governor Northam's registration stuff? Now, here's the deal. I'm a lawyer, not picking sides here. I'm just looking for ways that maybe we could interfere with this. So let me tell you just very quickly what happened. Back in the 80s, President Reagan produced this transportation bill, which basically, I've known about it for a long time in the context of what it is. But basically, if you're just traveling through a state, you are not generally subjected to the state laws regarding firearms. So if I have a firearm with a magazine capacity of 15 and I'm driving through New Jersey and I get stopped by the New Jersey cops, then that firearm would not necessarily be illegal in New Jersey because I am just traveling through. President Reagan pushed this through back in the 80s. So the point of this was it was reincorporating the 1964 Gun Control Act, which applies to all of the states. And why I think maybe this will work. Now, again, I am not saying this is going to work. All right, I want to be very clear about this. But why I think this may work is that there is a competing code section, which is 18 USC 927. And what's important about 927 is it's talking about this title having effect on state law. And it says, no provision of this chapter shall be construed as indicating an intent on the part of Congress to occupy the field in which such provision operates to the exclusion of the law of any state on the same subject matter, unless there is direct and positive conflict between such provisions of law of the state, so that the two cannot be reconciled or consistently stand together. Okay, so a lot of lawyer talk here, but essentially here's my argument. And again, don't rely on me. This is going to judge. I'm not anything more than just a lawyer trying to think outside of the box. But essentially, the federal government said, we don't want registries of firearms at the federal level. And then you'll have a state that's going to say, hey, in order to get the benefits of a grandfather clause, you have to register your firearms. So what that does is that's conflicting with the federal intention of Congress, because it says in 927 that no provision of this chapter shall be construed as indicating an intent on the part of the Congress, except when the state laws conflict with the federal laws. So that's what I'm saying. Maybe we can make an argument in federal court that registry of non-NFA firearms, so things like automatic weapons and suppressors and shotguns, things like that. Maybe we can make an argument in federal court that says that it was the intent of Congress not to have a registry. States doing registry directly impacts on what congressional intent was, and because of that, because Congress has the supreme law of the land to be able to make laws on guns, then maybe those two conflict hard enough for a federal judge to jump in. Now, I've looked up the codes, I've looked up the laws. I'm, quite honestly telling you, I cannot look at every case that exists, because there's places like the District of Columbia and New Jersey and Connecticut where registries have passed whatever their scrutiny is, and there are other states like Florida that have state laws that ban firearm registries. So there are states that have outright said you can't register in our state, and then there are states like New Jersey where registry is legal and seems to have passed. I can't find where my argument has been made anywhere reasonably in the argument, which is the argument is this: I have a lawful firearm today. It's now going to be a felony to own it tomorrow. And not tomorrow, I'm just saying, for example, tomorrow. And the only way I can keep that is to go through a registry with the state. That's the deal I have to make with the state. So that's a very unique fact pattern. Maybe 18 U.S.C. 926 and maybe 18 U.S.C. 927 can come together. I'm thinking out of the box. Maybe that's a big bunch of crap, okay? Maybe we go to federal court and they are like, where'd you get your law license, you idiot? That's the stupidest argument we've ever made. Maybe. Or maybe it works. I'm throwing that out there for you to talk about. I'm throwing that out there for you to talk to your lawyer friends about. If your lawyer's looking at this, please give me your feedback. I would love to see it. Maybe we have something here. Maybe we don't. But right now, we don't got much. So something's better than nothing. And even if this something doesn't work, maybe it will influence Richmond to think, we don't want to go down that road. We don't want to go down that fight. And I'll be quite honest, these states that have registries are very convinced that they're right. I haven't seen anything. There's the McDonald case from the Supreme Court. It does not talk about registries as something that would be reasonable for states to do. It doesn't say you can. It doesn't say you can't. It does have a list of things that says that they can do, but it doesn't say registry. So the Supreme Court has not weighed in, yes or no, whether a state can have a registry. So it's just something to talk about. And as I've said from the beginning, we have to make different arguments. We have to make creative arguments. I'm throwing this out there. I'm putting my reputation out there to say, hey, this might be something we can argue that other states haven't, that other lawyers haven't, because maybe it's just too stupid of an idea, or maybe just nobody's thought of it. I don't know. But it's something, it gives me a little hope that maybe we have something to go to federal court on. Rewatch this video if you're just tuning in right now. Maybe it'll work. I'm sorry that the last video got deleted. It got deleted because it violated a Facebook policy, which I have not violated in this video, so we should be able to keep it published and keep it up. So anyway, Facebook, have a great day.